Hi, my name is Sari de Breu. I'm an IP lawyer, and in this video I will be taking you through some of the intellectual property issues related to open innovation. Let's start with the question, what is open innovation? So open innovation is any type of collaboration with persons or entities outside your organization. The purpose is to accelerate innovation. You can achieve certain innovation within your organization, of course, but sometimes it's faster to achieve this innovation when you collaborate with companies that have more experience in this particular technology. This collaboration can lead you to work with technologies outside your comfort zone and with companies outside your sector. The basis of this open innovation is the sharing of information. You will be sharing some know-how with your partners, and your partners ideally will be sharing some know-how with you. Open innovation can take different forms. More traditional examples can be found in collaborations between companies and universities, consultancy, joint research and development projects, or joint ventures. But then there's more experimental and newer forms of collaboration, such as hackathons, crowdsourcing, or innovation booster initiatives. Open innovation in an uncontrolled environment might entail some risk. You will be engaging in open discussions with third parties to explore potential new partnerships. Now, sharing information in such context might create some threats to your existing business model, especially if your business is based on some key confidential information. Also, because the future business models might not be very clear yet, the sharing of information might also create a risk for developing new revenue streams. Firstly, sharing information might create a risk for the protection of existing assets. So for example, if you already have developed some inventions for which your company has not yet applied for patent protection, sharing technical information might harm the novelty condition that is a prerequisite for patent protection. Also, in copyright, you don't need to register for any type of copyright. It's an automatic protection, but still sharing too much information about copyright protected works, such as software, might create some evidence problems on when you have created these works and who was the author. And then, of course, if you share information that is actually protected as confidential information, but you don't have a non-disclosure agreement in place, then the trade secret, the protection as a trade secret, might be harmed as well. Second point, you should also discuss the resulting innovation of any collaboration. What will happen if you find something really new, something really interesting? You should be aware of the risk that one of your partners might be appropriating the intellectual property or the trade secrets. So it's good to make some agreements on who gets to commercialize the resulting creations. So it is important for you to know the default rules. As a matter of principle, all information that you share with your partners may be used freely. So concepts, ideas, methods that you disclose to your partners, they can use without your consent and even without you knowing, unless this information is protected under intellectual property rights, such as patents or copyrights, or if your information is protected as a trade secret or as confidential information. In that case, you need to put some factual, practical measures in place, and you should get some contractual protection in the form of a non-disclosure agreement. So depending on the type of asset, the type of technology with which you are working, different rules apply, and even at the same time. So for example, if you're developing some kind of wearable to monitor a heart rate while doing physical activities, this device might be connected to a phone, might be collecting data, and all kinds of interesting applications may be done with these data. Now, the wearable device in this case will be a hardware, there will be some software, there might be some code, some algorithms, and there's data. Now, for each of these components, you need to know which protection applies. The wearable might be protected under a patent, the software might be protected under copyright, even trade secrets might apply. And for the data, you need to know whether these data are important, yes or no, and if you can share them with or without a non-disclosure agreement. This means, all in all, that you need to have some legal tools in place to manage your open innovation. At all times, you need to be aware of your risk when you share information with your partners, but you also need to be aware of the risk that your partners take when they share information with you. This means that you need to have a very good idea of the information that you have and you hold before the collaboration. This is what we call background information. You need to know which technology, which assets are protected under patent, under copyright, or under secrecy. And you need to know this before sharing this information with your partners. Secondly, you also need to know what will happen with the information, the innovation that might result from your collaboration. This is what we call foreground information. It's useful to keep track of the foreground information as it is being created, for example, using a lab book. It's also useful to discuss with your partners whether such information can be used, whether it belongs to you, whether it belongs to your partner, whether you have some kind of joint ownership, and who can use this information. So if there is any innovation, can you use this information? Can your partner further develop the information? Under which conditions and with which consent? Good luck.